Here's a segment from a recent Gun Talk radio episode. You can listen to all the Gun Talk radio podcasts however you tune in, or check out guntalk.com for more. There's so much going on these days, and I'm amazed at people who don't know it, and they say, well, nobody's trying to pass gun bans. Well, maybe not in Congress at the moment, but certainly a lot of other places. A lot of the activities taking place locally or at state level, and certainly in courthouses. And one of the guys on the front lines of that, and has been, and does a great job with, is Adam Kraut from the Firearms Policy Coalition. Adam, thank you for joining us.
Yeah, thanks for having me, Tom.
You bet. I mean, I understand that if you're looking at Congress, you think nothing's going on, maybe, but it's a very busy time in the gun rights world, isn't it?
Absolutely. We, in the legal world, we are very busy. We have been very busy, and we will continue to be very busy.
Well, give me and people out there an idea of some of the things that the Firearms Policy Coalition has been working on.
Well, I'll do my best to try to keep it short, as expansive as it's been. We have been filing a number of lawsuits around the country dealing with so-called assault weapons bans, right to carry for those young adults, so the young adults between the ages of 18 to 20 that can't get carry permits in a lot of states because they don't issue them until they're over 21. 18 to 20 purchase in both long guns and challenging the federal handgun ban. We had a bunch of COVID-related cases. I mean, we're really kind of in a lot of different areas.
Well, let's talk about that last one for a second, because you actually won a couple of Ninth Circuit cases about closing gun stores.
Yes. So when the COVID shutdowns first started happening, we filed a number of lawsuits around the country. There were 3 in California specifically, 2 of which just had decisions out of the Ninth Circuit, and there's one more that we're waiting on. The 2 that just had decisions were the Ventura County shutdown as well as the Los Angeles County shutdown. And those, the Ninth Circuit said they reversed the lower court's decision, one which dismissed the case, the other which found for the county on the judgment on the pleadings, and essentially said that the county's actions had burdened the Second Amendment conduct based on a historical understanding of the scope of that right. And they sent it back down to the district court to go through the proceedings. And essentially, if you look at the Ninth Circuit's analysis, the way they spell it out, they said that, strict scrutiny should apply. So that's the highest level of scrutiny that could be applied to a case before a court. And came to the conclusion that even under strict scrutiny, there's no way these shutdowns would be able to pass muster and thus be constitutional. So in theory, the lower court proceedings should be fairly straightforward, and it'll be interesting to see how that shakes out. Having said that...
let me explain what was going on. They're closing gun stores because of COVID, but leaving open a lot of other kind of stores out there. And, of course, NSSF worked really hard as one of the outfits that worked hard to have gun stores declared essential businesses. But some of these entities in California said, we don't care, we're going to close them anyway.
Correct. And when we look at what was shut down versus what wasn't, we had put this in a number of our briefings, and I think even the complaints that, bicycle stores were still open and operating, but gun stores were not. I believe golf courses were allowed to operate, but, ranges were not. And there was just a complete lack of respect for the Californians' ability to exercise their Second Amendment rights. And one of the biggest problems is that California, unlike a lot of other states, you can't just walk in and purchase a gun and go home with it. In fact, there's a 10-day waiting period. And so when you look at the shutdowns, L.A. County shutdown was for a period of 11 days, which was the shorter of the 2. Ventura County was 48 days. But really, you got to add at least 10 days to that because if you went there on the first day it opened, you're still not getting a firearm for another 10 days. And the court essentially looked at this and said, the barring people from being able to acquire arms in order to exercise their Second Amendment rights during a time where they might need it the most is just something that we can't allow to happen, which is one of the reasons that they said that this burdened Second Amendment conduct.
Well, I know you hear this. People say, well, wait a minute, that came out of the Ninth Circuit? That sounds like a good decision for us.
Yeah, it came out of a panel, and so right now the Ventura County case, they did not file for a petition for en banc review, and en banc review is where they ask the court as a whole to rehear the case, and an en banc panel can overturn a panel decision. The LA County case, they asked for an extension in time to file a petition to ask the court for that review. That's not due yet. I don't have it in front of me, so I don't know when. It'll be soon that's due. And I suspect that the LA County will, in fact, file since they asked for an extension of time. So ultimately, it very well may end up before the full court. And if that does, it's possible they may overturn the panel decision. I don't know. It's going to depend on the composure of that.
All of this, I'm just guessing, putting words in your mouth here, but all of these types of cases, lawsuits, are aimed at pushing back on the idea that the Second Amendment isn't a real right, that we can go ahead and do stuff to it, because it's not like the First Amendment. It's not a real right. And the things that you're doing in this and all these other cases is basically saying, no, this is a real right and it needs to be respected. Is that a fair analysis?
Yeah, absolutely. I mean, one of the ways I try to explain it to people is we're involved in the restoration of the right, the restoration to the understanding of what that right encompassed at the time of the founding. And if you look at court precedent, the Supreme Court has repeatedly said in a number of different instances, not solely related to the Second Amendment, but other rights as well, you need to look at how the right was understood at the time of adoption. And when we look at it through that lens, which is why we urge courts when they're looking at Second Amendment cases to look at the text of the Second Amendment as informed by history and tradition. And when you look at it through that lens, all of these gun control measures that are out there couldn't possibly pass muster because the public at the time that the right was adopted would have never have stood for any of this stuff.
Well, I mean, and I'm watching President Joe Biden this week at his gun control speech. And to your point of what could you do then, how would it have been understood when the Second Amendment was written? And he says, at the time the Second Amendment was written, you couldn't own a cannon, so why would you be able to own an assault weapon now? And I'm thinking, not only could you buy a cannon, could you own a cannon at the time of the writing of the Second Amendment, you could own a warship full of cannons at the time. Are they that ignorant of the law or of the history?
I don't think it's ignorance. I mean, perhaps for some, but I think it's one of those, the old thing, if you repeat a lie enough, it becomes truth. I think that if you just keep saying things and the public consumes it and doesn't look for more information to figure out whether or not, let's face it, most people will take things at face value. So if you're told one thing and you say, okay, well, President said that you couldn't own a cannon, so you must not have been able to own a cannon. I think a lot of it's just an intentional talking point.
That makes sense. Yeah, we'll just set this up, and the media will repeat it, and very few in the media will challenge it, and only some of the right-wing or the gun-centric websites will actually call it out and say, no, that's not what it is, and basically they get away with it. Hey, Adam, I'm going to get you to hold on a second here. Take a quick break. We're talking with Adam Kraut from the Firearms Policy Coalition with news of a lot of the cases that they're working on, and they're winning a bunch of them, and some are at the state level, some are local, and some are federal. All right, we're talking with Adam Kraut from the Firearms Policy Coalition. Adam, I'm looking at one of the cases you guys have just filed. I guess just filed it. Was it Newton versus United States? It looks like it's like a 40-year-old event with this guy being denied his ability to own a gun. Can you kind of fill us in on what that's about?
Yeah, I can give you a quick rundown on that. So in 1981, this guy got into a bar fight with two strangers in the Yosemite Valley. He was arrested by the United States Park Police, convicted of 2 federal misdemeanors. I think it was disorderly conduct and assault. He was given a very tiny fine, even for the time. He spent 6 days in jail and had 1 year probation. He went to buy a firearm somewhat recently, and he was denied by the National Instant Check System based on his 1981 conviction, so 40 years ago, because they said it was potentially prohibitive. they said that the convictions could qualify as misdemeanor crimes of domestic violence, which is a federally prohibited offense. But there's no evidence that domestic violence ever occurred. And essentially what the government said was, well, it's your burden to prove that these weren't domestic violence incidents or convictions. And he has no way to do that. He can't even obtain the court records from those proceedings because they've been destroyed. So what the government's really done here is they've, rather than the government having the burden and being able to show that he is in fact prohibited, they're saying that, well, it's up to you to tell us that you're not prohibited, which just flips it right on its head.
Well, okay, take that and extend it all the way out. They can say, okay, everybody's guilty unless you can prove you're innocent of something. Everybody's guilty. You have to come prove to us that you're innocent. And, it's the old deal. How can you prove a negative? Or this is, as you say, flipping the whole idea of being innocent until being proven guilty. This is kind of like some kind of Kafka Bizarro world.
Yeah, it's pretty wild, and unfortunately, he's not the only person that's been in this position. In private practice, I dealt with clients who were, the government was saying that you're prohibited unless you can show us otherwise, and a lot of times they found themselves in the same situation. They had a conviction from years ago. Court records were destroyed. They can't possibly get a hold of them, and they have no way of being able to produce something that says, well, actually, I was convicted of this thing, and it's not a prohibiting offense. It's wild that the government has taken this position rather than having the affirmative duty to show that this person is in fact prohibited.
So am I right? What you're seeking is for the court to say, no, the government, you can't shift the burden to be on the individual. You're going to have to prove that this person is prohibited rather than them proving that they're not.
Yeah, that's part of it. We're seeking that, specifically for him. We're also trying to enjoin the government from being able to take that position with other individuals as well. We're seeking relief under the Gun Control Act. There's a provision 925A that allows you to seek relief if you're wrongfully denied. So. This lawsuit was just filed the other week. I'm not even sure it's been served yet. I'd have to check my records to see, but I'm curious to see and interested to see where this one goes because it is a problem nationwide, and this is just it would be comical if it wasn't somebody's rights that were being infringed from this stuff.
Exactly. I mean, it really is like out of some kind of strange Russian kangaroo court system that you read about. But I'm so glad that you guys are doing that. I mean, another case I'm looking at, what is this? Illinois? Where is this? Where they're suing to protect gun owners' privacy. I'm looking at this one. This is that's Doe Brandis versus Attorney. Yeah, what is all that?
So California had passed Assembly Bill 173, and what that did was it allowed the California Department of Justice to share, among other things, personal identifying information of gun and ammunition owners. And remember, in California, in order to buy ammunition, you have to do that through a licensee where a background check's conducted.
That's right.
So all of this information gets collected in the DOJ's database, the Automated Firearms System. And so the bill that was passed would allow for that information to be shared with certain research centers for non-law enforcement purposes. And when you look at the law that set up a lot of the information systems, that information was protected and only able to be distributed for specific law enforcement purposes. So this created an exception to what the legislature previously had done. So we're suing over that in part based on a right to privacy that's protected by the California state constitution. Also, there's a Second Amendment claim in there as well. This certainly has a chilling effect on somebody wanting to be able to exercise their Second Amendment rights. And there's a number of problems with this. There's also no way for anybody to opt out of their information being provided. So if you purchased a gun previously, they're not going to contact you and say, hey, there was a request for the information.
Yeah,
is it okay if we share it? Or, So,
well, I'm thinking about it. I know people are saying, well, what's the concern? So, well, if they say that a research organization can get all this information, it could be somebody funded by Bloomberg that's like 3 different steps away from him. They get a hold of the records, and then they pull a Pentagon Papers, which is, we're going to put it all out on the internet with the names and addresses and phone numbers of everybody who bought guns over the last 50 years. And even if we get a court order that says we can't do that, once it's out there and can never be retrieved.
Yeah, it certainly could find its way out there and never be retrieved. I mean, if you look at the relief, that as part of the relief we sought in the complaint, it was kind of like a clawback provision where DOJ would have to notify all these places that had requested and received information, and they would be ordered to destroy that information and any record of it. So we're trying everything we can in order to prevent the further disclosure of any information that may have already been, but also protect the information that was already disclosed by, sort of clawing it back and forcing these research centers to have to destroy any information they do have.
Well, I mean, these are just a few examples of the many cases that you're working on and the things you guys are doing. I want to thank you for what you're doing. I mean, I'm just amazed at the number of actions that you're taking and how successful you've been at it.
Well, first of all, it's a team effort. I'm certainly not alone. There's a number of very brilliant people that work in the organization, and also we work with outside of the organization to make these things happen. We plan on continuing to be successful and aggressive. In fact, right now we're currently looking for plaintiffs for San Jose. Just passed an ordinance the other week related to requiring insurance. So we're actually currently looking for San Jose residents. We're looking for people who own at least one firearm. They're not a peace officer, don't have a concealed carry permit, and they're not considered indigent under California law. So if any of your listeners fit that criteria, I tell them to head on over to 2ahotline.com. Let us know. We'd be interested in talking to them. We're looking for plaintiffs for that. And then we're also looking for plaintiffs for more 18 to 20 handgun purchase challenges.
And it's 2ahotline.com?
Yes.
Very good. Adam, thank you so much. I appreciate it. Firearms Policy Coalition. Check it out, firearmspolicy.org.